Namaskar. Welcome to my channel Journey of Constitution of India. Friends, this is Wednesday and the time for current cases series. You are watching part 2 of this series. The name of the video is Irrational Restriction on Bail by Section 37 of NDPS Act is against law and justice. Why justice does not require proof of innocence before bail, and why this is put the condition here that a person has to prove his innocence of bail, or his judge has to reasonably conclude that innocence of his before at the time of considering the bail. Friends, we all know that bail is so difficult in NDPS case. The stringent conditions put by amendment in Article 37 of the Act in 1989 are so unreasonable to prudent mind. Even interim bail for genuine reasons is made very difficult, and sometimes if we succeed, then it is only due to the lady luck smiles on us. In this video, we will try to explore the better chances of bail. Let me add here that I read one study which shows that our Delhi High Court is more lenient and giving bail in more cases than any other High Court in India. Recently, two important judgments related to NDPS Act I read, which is passed by Supreme Court recently. One is related to the bail under Section 37 of NDPS Act, and the other judgment which relates to the considering of neutral material in the drug at the time of coming to the conclusion of whether it is commercial quantity or not. The first case is State of Kerala versus RAJESH Criminal Appeal number 154-157 of 2020, decided by the bench of Justice Indu Malhotra and Justice Ajay Rastogi, wherein bail granted by Kerala High Court was challenged by state, and the same was the bail order was granting bail or bail was set aside by the Supreme Court on the ground that the High Court did not comply the requirement of Section 37 of the Act. The second case is Rhea Singh versus Union of India, wherein Supreme Court was to decide the reference made to the judging the considering the legality of the judgment in E. Michael Raj versus Intelligence Officer Narcotic Control Bureau of 2008. In Michael Raj case, while considering the total amount of the drug and the purity of the drug for consideration for the purpose of deciding the commercial quantity, the neutral material was to be excluded. So this was the ratio, and it was under challenge. Last week, two things happened. That's why I decided to make the video on Article 37. First, I had to argue on interim bail petition in the High Court. And second, one of my friends who discussed this matter of bail of Section 37, under Section 37, and he requested me to make the video on 37. Let me brief some legal provisions of NDPS Act, which makes it on different footing. First, all offences of NDPS Acts are cognizable under Section 37(1). Second, it means that even a small offence, and for a small offence, the accused can be arrested by police without warrant. Second, that a special court tries the all matter and treats these all offences as a special offence. Second, important point here is that reverse presumption and reverse onus. In normal case, the criminal prosecution presumption is in favor of the accused and as a presumption of innocence, and prosecution is placed with heavy burden to prove its case beyond reasonable doubt. Whereas the situation differs in case of NDPS in the offences for NDPS Act. The other most important thing here is the stringent provision conditions put by Section 37 against bail. Normally, there is no chance of getting anticipatory bail, and so the only option left with is the regular bail, and which is also very, very difficult. Let me tell you, normally there are two kinds of cases in NDPS Act. One is based on recovery of drugs by investigating agencies or police, or second, the disclosure of co-accused against some person. Section 54 of the NDPS Act calls for a presumption that the accused has committed an offence about the material is found in his possession until and unless it is found contrary, and that is proved. So this is reverse burden. In the case of disclosure, even a slight corroborative evidence put the accused in a very difficult condition, like phone trapping a phone call or even a remote transaction of money. So the bail becomes very difficult in these two kinds of cases. Supreme Court in Syed Muhammad Syed Umar Syed versus State of Gujarat, that is 1995 SCC volume 3 610, stated that Section 54 of the NDPS Act shifts the onus on proving his innocence upon the accused. It states that trial under the NDPS Act, it may be presumed unless and until the contrary is proved that accused has committed the offence. If he fails to prove satisfactorily the possession of drug, then the entire thing goes against him. With these backgrounds in mind, we will go to the section 37 of the Act. So we should start from the scratch. First of all, what is bail? Bail is not defined in CRPC. The provisions of bail are given in 437, section 437, 438 and 439. But Supreme Court in various cases had categorically stated that in case of conflict between CRPC and NDPS, section 37 of NDPS Act, the section 37 of NDPS Act will prevail over the provisions of CRPC. Before I go further, let me quote a very famous line on bail by Justice V.R. Krishna Iyer. I quote, "The issue of bail is one of liberty, justice, public safety, and burden of public treasury, all of which insist that a developed jurisprudence on bail is integral to a socially sanitized judicial process." So these four factors are to be considered before granting a bail by the court. As a student of law, I understand the basic concept of bail is to strike a balance between the individual liberty and the general interest of society at large. As a practicing advocate, I feel the rigor of Section 37 of NDPS Act needs reconsideration by the legislature to reframe it, or by the judiciary to reconsider it. Before going further, let us see the text of Section 37 of NDPS Act. Section 37 reads with the headline is offences to be cognizable and non-bailable. First, notwithstanding anything contained in code of CRPC, A. Every offence punishable under the Act shall be cognizable. B. No person accused of offence punishable for offences under Section 19, 24 and 27A, and also for offences involving commercial quantity, shall be released on bail or on his bond, unless the public prosecutor has been given the opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and he is not likely to commit any offence while on bail. So the catch point is here, first, it is very ridiculous that the discretion of court starts after the public prosecutor chooses not to oppose the bail. It is very ridiculous, because if he chooses to oppose the bail, then only the court has to come to the reasonable satisfaction qua the 2 points. First, that the judge must have the reasonable ground for believing that he is not guilty, and second, he is not likely to commit any offence while on bail. These two restrictions are absolutely contrary to the criminal jurisprudence and the very scheme of judicial dispensation, justice dispensation. Suppose first condition is that a court is considering the bail application at the prior to filing of the charge sheet. Then he cannot come to the conclusion that he is not guilty of such offence. The second condition is when he is considering the bail application, a court is considering the bail application at the post charge sheet. Then the situation also becomes difficult because the court has to see the entire charge sheet and then has to come to the conclusion. How can a court come to the conclusion of the not guilty or guilty of a person considering the matter before trial? Because only after trial can come to the conclusion. Suppose a case where an accused is granted bail by High Court with the discussion of materials on recall and finding that the judge has a reasonable ground to believe that accused is not guilty of alleged offence. Now Session Court has to frame the charge. Then what will be the sanctity? Suppose in case bail is granted by High Court with this conclusion, then what will be the sanctity of the finding of the High Court that he is not guilty of? So this is a very precarious condition created by this section 37. This becomes more ridiculous when the court has to satisfy itself that while the person will be on bail, he will not commit any crime. Here the any crime means beyond NDPS also. How can a court come to this conclusion that he will not commit any crime? According to me, even the best psychologist armed with the best research tool or the best fortune teller cannot come to this conclusion that the future behavior of a person will be of a particular type or not a particular type, or he will not commit any crime in the future. Indirectly, these two conditions are such that accused has to be in jail till he is acquitted or he has completed the sentence which has been awarded by the court. There is no way out. Because these two conditions for the satisfaction of the court is also applicable in suspension of sentence. Even at the time when the suspension of sentence in the appeal it is considered, even then the rigors of section 37 has to be satisfied. So my take on today's discussion is section 37 warrants revisit by judiciary and reframing by legislature. Why I am saying so? Because a provision which was pari materia in Prevention of Money Laundering Act has been declared unconstitutional by Supreme Court in a case of Nikesh Tarachand Shah versus Union of India 2017 AIR Supreme Court 5500. Now this coming to the Supreme Court case recently passed, which I discussed, the state of Kerala versus Rajesh, in which the basic fact was that Trivandrum police has arrested 3 persons and seized hashish oil, money and vehicle. One of the accused made the disclosure statement that this hashish oil has been supplied by the accused Rajesh, which is respondent here, and to sell in the international market. Session Court rejected the bail application filed by the other accused with the current accused also. Later on, High Court granted the other 3 accused bail, but those bail order were not challenged by the state. So after that, considering the ground of parity, the present accused was also granted bail by the High Court. And this bail application was challenged first by moving an application. Bail order was challenged first by moving an application under 482 before the High Court, wherein High Court found that the remedy lies in the Superior Court because it would amount to review of the bail order. So the state challenged this bail order by High Court in SLP before Supreme Court. While dealing the present case, Supreme Court heavily relied on a previous judgment in Union of India versus Ram, Samuj and others, 1999, Volume 9, SCC 429, wherein the court has heavily considered the social object of the law, stating that the act is to check the menace of dangerous drugs flooding the market, and Parliament has provided that the person accused of offences under NDPS Act should not be released on bail during trial unless mandatory conditions provided under Section 37, namely that there are reasonable grounds for judge or court to believe that the accused is not guilty of such offence, or there is not likely to commit any offence in future. So, relying on these basic ideas, the Supreme Court set aside the order passed by Kerala High Court. And so, this case was there. While I reading the case, I felt that the judgment written by Kerala High Court relying on granting the bail on the basis of parity was a good law considering the criminal jurisprudence. Because again, why this discretion of a state or public prosecutor is given so much importance, and that are being giving the opportunity for the state agency to use that with the discrimination is the point which I want to put before you. Supreme Court set aside the order saying that the order cannot be sustained because the court did not give finding to the satisfaction on the 2 points of he is not guilty and he will not commit any future crime. So that was not the occasion for the High Court to consider, because High Court had granted on the different footing. This was on the part of a state to go and challenge the bail application of the earlier accused. Then it would have been on the better condition for on the point of justice. The question is why SC did not find the ground of parity applicable in this case. Is it not the case of misuse or discretion by the state agency? So these are the points which I want to say, that misuse of discretion is the byproduct of the harsh conditions of Section 37 of the Act, which needs revision. The another point which I want to discuss here, that the need of speedy trial, because the trial remains concluded for 3-4 years normally in this case of NDPS. So the person has to languish in this jail. Recently, I was listening one Bivna of his retired High Court judge, and he told that he acquitted an accused just 1 month before the completion of his entire sentence of 10 years. So what is the value of this acquittal when he has only 1 month to go on completing his 10 years? So speedy trial, speedy hearing of appeal, these are the hard realities which must be considered in reframing the provisions of Section 37 or revisiting by the judiciary higher courts in provisions of the Section 37. Most of the time, there is one also aspect that the drugs collected are sent to laboratory for checking the contents of the drug and deciding the nature of the drug. And suppose after having spent 1 year, 5-6 months, it comes to that the drug was not under the contraband articles. Then again the drug is sent to the other laboratory. So this all takes time, and this requires that a human approach should be there in the Section 37 instead of making this stringent provision considering the menace of the drug. Law says denial of bail to and under trial is antithetic to the principle of justice and liberty. And in the present condition, when so much time is taken, we think that this provisions of 34 needs the equal treatment which was given to the similar provision of Prohibition of Money Laundering Act, Prevention of Money Laundering Act, and should be given. And so it should be also declared unconstitutional. What I feel that a clause, if it is not possible, then a clause in this Section 37 be put, that if the trial is not concluded for a certain period of time, then these rigors will not be applicable while granting the bail. Much needs to discuss on this point. There are several important judgments of Supreme Court and High Court, and those really need to discuss to understand. Thank you very much for watching this video. Please subscribe to my channel, make the comment on the contents of the video. Namaskar.